Hi there. Thank you so much. Like she said, my name is Taylor Brewer. I hope everyone's having a good afternoon. I'm here with my colleague, Rachael Andrews from Venskus and Associates. She'll be introducing herself to you shortly. Our presentation for you today is a primer on housing rights and protections for domestic violence survivors. So let's go into our presentation roadmap. So we'll just give you a brief introductions of ourselves and our organization and firm, and then we'll move on to survivors in housing, talking generally about private housing, and also giving an introduction to kind of the laws that we'll be working under and speaking about today. Then we'll move on to more federally subsidized housing and laws that protect DV survivors there. So VAWA, and speaking generally about Section 8. We'll move on to fair housing and discrimination and discuss other resources. And then after that, we will take some questions if we have time. So jumping into just a brief introduction about the California Women's Law Center. We were founded in 1989 and are a nonprofit law and policy center dedicated to advancing justice for women and girls. We are a support center, which is an organization whose main purpose is to provide legal and technical assistance, legal training and advocacy support. This means we don't provide direct legal services, but provide help for organizations that do.
Good morning. My name is Rachael Andrews. It's such a pleasure to be here, and I appreciate your time and your interest in this subject. I'm an associate with Venskus and Associates. Venskus and Associates is a public interest law firm dedicated to providing high-quality legal services for traditionally underrepresented individuals and civic groups. Our attorneys successfully represent tenants facing wrongful evictions, illegal rent increases, discrimination, harassment, and habitability matters that affect tenants' quality of life. I will start off our discussion on the intersection of housing instability and domestic violence with a brief overview of the laws protective of survivors. Housing insecurity and domestic violence are fundamentally linked. Neither can be solved without addressing the other. Housing insecurity is a primary reason why survivors across genders and age ranges stay in abusive relationships, and why children continue to be exposed to domestic violence, which is a key risk factor for not only future perpetration, but also chronic health conditions. Unstable housing and homelessness make both survivors and children vulnerable to new forms of violence, which creates a still greater risk that the cycle of violence will continue into new generations. Some statistics noted on this slide, 80% of mothers and children experiencing homelessness had previously experienced domestic violence. People who experience housing instability are 4 times more likely to experience domestic violence, and survivors often face discrimination from landlords because of the abuse they experience, which makes housing stability even more difficult for them. So what kind of laws protect housing for survivors? State and federal law. California laws in particular have created many protections for survivor-specific situations in housing, meaning that California laws have protections that cover situations that arise specifically in a context where abuse is occurring or has occurred. Federal law protects certain rights of survivors in subsidized housing, including those with Section 8 vouchers. Both California and federal law protect survivors against housing discrimination. I'll start with some of our California state laws. The first, the Domestic Violence Prevention Act, which is codified at Family Code sections 6321, 6324, and 6340. This act provides survivors with avenues to remove abusers from their home and also to require their abusers to continue to pay the abuser's portion of rent or mortgage. California Civil Code sections 1941.5, 1941.6, 1946.7, and 1946.8, as well as Code of Civil Procedure section 1161.3, in various ways allow survivors of domestic violence, stalking, sexual assault, human trafficking, and elder or dependent adult abuse to change their locks or to have the landlord change their locks, as well as terminate their leases early. It also provides survivors with eviction protections, meaning affirmative defenses against unlawful detainer. And California Government Code sections 6205 to 6211 allows survivors to make their address confidential. Government Code section 53165 prohibits local agencies from promulgating rules or ordinances that would penalize survivors of their landlords because of law enforcement being called for assistance. Finally, under California state law, the Fair Employment and Housing Act, which is codified in relevant part at Government Code sections 12955 to 12957, provides protections against housing discrimination based on race, color, religion, sex, gender, gender identity, gender expression, sexual orientation, marital status, national origin, ancestry, familial status, source of income, disability, veteran or military status, or genetic information. Moving on to federal laws that are protective of the housing rights of survivors of domestic violence, they include the Violence Against Women Act and the Fair Housing Act. The Violence Against Women Act is codified at 34 U.S.C. section 1249, and it protects survivors living in certain subsidized housing by making it illegal to deny housing to survivors of domestic violence, sexual assault, dating violence, and stalking. It also disallows termination of the housing of these survivors and otherwise disallows landlords from penalizing them because of their status as survivors. The Fair Housing Act, codified at 42 U.S.C. section 3601 and following, provides protections against housing discrimination based on race, color, religion, national origin, sex, disability, and familial status.
Thank you, Rachel. So now we'll go into kind of specific instances or specific issues that will come up or have come up regarding survivors of domestic violence. And so one specific issue would be getting an abuser to move out of the unit. So relationships that qualify for a DVTRO. So this is a domestic violence temporary restraining order. So you can get a domestic violence temporary restraining order against someone you have had an intimate relationship with or someone you're closely related to. This includes a spouse or domestic partner, someone the survivor has been through a divorce or separation with, someone the survivor dates or used to date, someone the survivor lives with or used to live with, the other parent of the survivor's child, or someone the survivor is closely related to. So in this scenario, the survivor can seek a domestic violence temporary restraining order. These restraining orders can sometimes be important as documentation to assert other rights, which we will discuss later. The court uses a DVTRO to help protect people who have been abused by someone who they have an intimate relationship or are closely related to. The court can grant additional protections with the TRO, including an order for the abuser to move out of a shared home and an order for the abuser to pay rent. So how to get a DVTRO with a move out order specifically. So to get a DVTRO with a move-out order, a survivor must show that the abuser assaulted or threatened to assault the survivor or their child. Physical or emotional harm would result to the survivor or their child if the abuser were not excluded for the home. And the survivor can reasonably argue their right to use and possess the apartment. And so that specific, the last note that I read there can be a little tricky at times. For example, what if the survivor's name is not on the lease? So if the survivor can show the court any reason why they have the right to live on the property, they can ask for a move-out order and order to pay rent with their DVTRO. So if you can reasonably argue your right under the color of law to use the home, you can get these protections. So right under the color of law to use the home can mean different things in different instances. For example, someone who is not on the lease, but may have right under the color of law because they live on the property and pay part of the rent. Someone who is not listed on the property deed may have a right under the color of law because they pay a portion of the mortgage or property taxes. Someone can also have the right to the color of law if they contribute to the household in other ways, such as by cleaning or buying food for the household. So this can look different in each circumstance. If you pay part of the rent, contribute to property taxes or mortgage payment, or contribute in other ways such as buying food, those are all arguments that the court can consider. So after the abuser leaves, how can a survivor get the locks changed? So the survivor would then need to write to a landlord that they are requesting to change their locks. So they must provide the landlord a copy of the DVTRO with move-out order. The landlord must then change the locks within 24 hours. If not, you can change, if the landlord does not change the locks within 24 hours, the survivor can then change the locks themselves, but you need to use the same or better quality lock and give the landlord a copy of the key. And this falls under California Civil Code 1941.5 and 1941.6. So if the parties are not intimate partners, but only roommates, can someone file a domestic violence restraining order and have the other locked out? The answer is it depends. The Domestic Violence Prevention Act, which Rachel referenced earlier, includes cohabitants in its qualifying relationships. However, cohabitant has been defined by the California Court of Appeals to require the cohabitants reside in a family or social unit. And this can be found at the O'Kane v. Irvine case as referenced here.
So now we'll turn to a different set of scenarios that involve protections against discrimination against a survivor from the landlord. So scenario number one, if the landlord gives a survivor an eviction notice because the police or an ambulance came to the survivor's house, the law provides the survivor a defense to eviction on this basis. This means that unless the landlord can show that they're evicting the survivor for another reason, lawful and not pretextual, that the court should let the survivor stay in their home. To reiterate, a landlord cannot evict a tenant for using emergency services. And these laws are available at Code of Civil Procedure section 1161.3 and Civil Code section 1946.8. Moving on, if the landlord gives the survivor an eviction notice because the survivor's abuser, who does not live with them, came to the house, again, the survivor has a defense to eviction. A landlord is not permitted from evicting a tenant for experiencing domestic violence at the hands of an individual who does not live with that tenant. Code of Civil Procedure, section 1161.3, again, will provide that affirmative defense to unlawful detainer. Next, to defend against an eviction because of abuse, the survivor must show one of the following to prove to the court that the abuse has occurred. The survivor can show a police report within the last 180 days that shows that the abuse occurred and that the abuser in question is the one who committed the abuse. The survivor can show a restraining or protective order that was entered within the last 180 days. Or the survivor can show a letter from someone called a qualified third party, examples of which, non-exclusive examples of which, include a doctor, a nurse, a psychologist, a social worker, or a domestic violence or sexual assault counselor. I will note that a landlord can evict a survivor if they allow the abuser back on the premises after receiving the 3-day notice or after the 3-day notice expires, only if the landlord reasonably believes that the abuser poses a physical threat to other tenants at the property or the right of those other tenants to quiet possession of their unit. The tenant can also still have an affirmative defense against unlawful detainer if the abuser's act of showing up at the unit was itself domestic violence. And in other words, the tenant didn't let the abuser on the property, but the tenant did not have a choice in allowing the abuser into the home. This scenario would arise, like, let's say that the abuser shows up and is banging on the door. The entry itself is abuse, and denying the entry could have resulted in harm to the tenant or their family. Other options available are to help the survivor move out of the home. So if the survivor decides the safer option is for them to move out and relinquish their tenancy, for example, if they fear that the abuser will return to the home, or if the abuser has been coming back to the home and continues to harass the survivor, or perhaps just that the survivor has located safer alternative housing, the survivor can end their lease early. However, in order to avail themselves of this, they must tell their landlord in writing that they are ending the lease early, and they also have to provide, similar to the previous slide, certain documentation of the abuse that forms the basis of their need to terminate their lease. So that documentation can be a police report within the last 180 days that shows that the abuse occurred and that the abuser in question is the one who committed the abuse. It can also be a restraining or protective order issued in the last 180 days. It can be, similarly as above, a letter from a qualified third party that the abuse took place. Or this law also provides for other documentation that shows that the crime or abuse occurred. Again, this allows a tenant to end their lease before the contracted end date by telling the landlord in writing that they are ending the lease early and by showing one of these forms of documentation. Civil Code section 1946.7 is the statute that allows this termination of lease. With respect to the documentation that a tenant needs to provide a landlord to support terminating their lease, a landlord is not allowed to share the information that the survivor gives unless one of three things: the survivor permits it, says it's allowed in writing, the landlord is under a court order or there's a law requiring the landlord to disclose the information, or that person is talking to the qualified third party that supported the tenant's need to vacate the property. These, again, are provided at Civil Code section 1946.7 and Code of Civil Procedure section 1161.3. This is important because a survivor may be hesitant to share this sensitive information with their landlord. This provides some level of protection to the survivor in exchange for the need to provide it so that they can move out of their unit. Next are monetary considerations for a tenant who's considering terminating their lease due to domestic violence. Survivors do still have to pay rent after they break the lease early. However, they only have to pay rent for the next 14 days after they tell the landlord that they are moving out. Again, this is under 1946.7, where they have notified the landlord that they're not only moving out, but also provided the landlord with the documentation of abuse. However, if the landlord rents the unit to another tenant before the 14 days elapse, the landlord must return any money to the survivor that they collected for rent during that time period. A landlord may not withhold the security deposit of a tenant who avails themselves of this. They are still under the standard protections or laws applicable to return of security deposits, meaning that a tenant utilizing this provision of the law to terminate their lease, it does not affect at all the right to recover their security deposit. A landlord must return the security deposit within 21 days and list out any deductions that they make. If a tenant avails themselves of this protection, a subsequent landlord cannot refuse to rent to a survivor because they broke another lease early. Somewhat related, a landlord can deny an application, generally speaking, because a tenant applicant has a criminal history, but only if that criminal history would make the applicant a risk to the health and safety of other tenants on the property. This comes up in this context because oftentimes survivors of domestic abuse may have their own criminal histories related to the abuse, and landlords historically, perhaps categorically, would bar applicants who had any sort of criminal history. However, recently, I believe in like 2020, regulations were implemented with respect to FEHA, the Fair Employment and Housing Act, with respect to the use of criminal history in housing. So the new rules are that although a landlord can deny an application because of criminal history, and a landlord is permitted to check an applicant's criminal history, if the landlord intends to deny housing on the basis of a conviction, that conviction must be a directly related conviction. In other words, the conviction would have a direct negative bearing on a non-discriminatory interest of the landlord. For example, ensuring the safety of other residents. However, when they're considering denying an application on the basis of criminal history, landlords are instructed to consider mitigating information. And one specific example of that mitigating information includes whether the criminal conduct arose from the applicant's status as a survivor of domestic abuse. So in summary, if a landlord is having trouble with their landlord, as attorneys, we should be counseling those tenants and survivors to keep all documentation, to find legal counsel, to never sign anything that is untrue, and to always deal with the landlord through writing. And those are admonitions I would give to tenants in any context, but also specifically important in this context.
Okay. So now we'll move forward onto federally subsidized and funded housing. Specifically, we'll speak towards Section 8 housing and VAWA, the Violence Against Women Act. So beginning with Section 8 housing. If neither the survivor nor the person they live with has a Section 8 voucher, unfortunately, it's a very long process to obtain one. There is a waiting list, but if the survivor has been living with their abuser and the abuser has Section 8 voucher, the process for a survivor to obtain their own Section 8 voucher is much faster. They will have to be eligible. So first, let's discuss eligibility. So the Housing Choice Voucher Program is the federal government's main program to assist very low income families, the elderly. Sorry, I lost my place on my slide. Give me 1 second. There we go. The elderly and disabled persons to afford safe housing in the private housing market. So it discusses three separate income statuses. So extremely low income, income that does not exceed the higher of the federal poverty level or 30% of the area median income, very low income, 50% of the median income, and then low income, 80% of the area median income. So HUD's income limits for Los Angeles, which is what you're looking at right now, are on the table that you see. Only families meeting extremely low, very low income standards are eligible for Section 8 assistance. Section 8 assistance is available to only U.S. citizens, non-citizens with legal immigration statuses, and quote unquote mixed families, or families in which at least one but not all members have eligible immigration status. So assistance to mixed families will be prorated. The same program rules and regulations for determining eligibility status for Section 8 rental assistance apply to everyone. And so we'll discuss the Violence Against Women Act. So VAWA 2022 took effect on October 1st, 2022. This was a reauthorization of the Violence Against Women Act. Some key establishments of the reauthorization include it establishes within HUD a gender-based violence prevention office with a VAWA director who will oversee the implementation of VAWA housing title within HUD, and in coordination with other federal agencies. It protects the rights of survivors to report a crime and emergencies from their homes without fear of punishment or eviction. It expands the current definition of homelessness to reflect accurately the experiences and realities of sexual assault survivors. It provides for VAWA housing related training and technical assistance, and it creates a review process for covered housing providers compliance with VAWA to improve implementation of the Act's existing protections. So protections for DV survivors under VAWA. So here are some kind of the main protections. So it prohibits certain housing providers from discriminating against or evicting a survivor of domestic violence, dating violence, sexual assault, or stalking because they are a survivor. Requires tenants to receive notice of VAWA protections. Requires housing providers to keep a tenant status as a survivor confidential. Requires that survivors have access to emergency transfer plans when they need to move because of abuse, and allows providers to split a survivor's lease, ending the abuser's tenancy and allowing a survivor to stay. So just a note on emergency transfer plans, it would move to another unit in the same housing program if available, or in another housing program if eligible. So I'll make a note here that tenants in subsidized housing also have all of the legal protections given to tenants in private housing. So in addition to the protections from VAWA, tenants in subsidized housing may request a restraining order with a move-out order, change their apartment locks, terminate lease early, or have the same defenses to eviction that we discussed prior. Okay, so which public housing programs does VAWA apply to? So there's a list here. I won't read all of them to you, but I will note that the bolded programs are housing programs available to people with all immigration statuses. So that being Section 202, Section 811, housing for people with disabilities, home, LIHTC housing, Section 221 D3, below market interest rate. And so we'll move on to options when an abuser has Section 8, has the Section 8 voucher and the survivor does not. So what under VAWA, the landlord may choose to evict the abuser and not the survivor. If the person they live with is the Section 8 voucher holder, but the survivor is not, the Public Housing Authority must provide a survivor the opportunity to get their own Section 8 housing choice voucher. I will make a note here that in a recent case last year, Will v. Gallegos, the domestic violence survivor requested a DVRO with a move-out order, which would have excluded the perpetrator from their shared unit. The trial court granted a DVRO, but denied the move-out order, saying that it was up to the landlord, not the court, to decide who got to stay in the unit. The survivor appealed, and the Court of Appeal reversed the trial court's judgment, finding that under the DVPA, the Domestic Violence Prevention Act, a court has the power to order a restrained party to move out of a shared rental unit, as well as the power to impose conditions, such as who may pay the lease and utilities. And the court also recognized that a landlord does not have the legal authority to terminate only one person's tenancy through the unlawful detainer process. So that would be a distinct difference between VAWA and DVPA protections, as mentioned in the last slide. Under VAWA, the landlord may choose to evict the abuser and not the survivor, while under DVPA protections, so what covers the covers private tenants in court also recognize that the landlord does not have the legal authority to terminate only one person's tenancy through the unlawful detainer process. So I just wanted to flag this case as something that may come up. The publication request submitted to the California Supreme Court in November 2022 was denied, so this is not citable authority, but I just wanted to flag this as something that may come up. So what happens if the survivor does not qualify for Section 8? So they've been living with their abuser has Section 8, but the survivor doesn't, and they want to leave. The Public Housing Authority has given them the opportunity to apply to Section 8 housing, but they do not qualify. So the Public Housing Authority must give the survivor reasonable time to get assistance from another housing program covered by VAWA that they may be eligible for, or find different housing. And so this is held under VAWA at 34 USC 12491. So moving forward. So VAWA protections if the survivor needs to move out. So this is if the survivor has Section 8 or lives under other federally subsidized programs or has other federally subsidized vouchers. So the Public Housing Authority Emergency Transfer Plan. So if a survivor lives in Section 8 housing or any other housing program that VAWA covers, we saw a list of those in the earlier slide, they can request an emergency transfer from their current unit to another unit. This is what the emergency transfer plan is. There we go. And so the Public Housing Authority has to allow tenants to make an internal emergency transfer when a safe unit is immediately available. So in an internal emergency transfer just means that a survivor would stay in Public Housing Authority's area of control, and they're not asking to transfer or port out to a different county. For example, if you move from Koreatown to Crenshaw, that is an internal transfer because the survivor would still live in LA City. When it says that the transfer can move into a safe unit, the survivor determines whether the unit is safe or not the housing authority. And when a safe unit is not immediately available, the PHA, the Public Housing Authority, also has to give priority to the transfer that's happening under VAWA, and the PHA has to take reasonable efforts to assist a tenant who wants to make an external emergency transfer when a safe unit is not immediately available. So an external emergency transfer is just when you move out of the PHA's domain. So just to recap, the Public Housing Authority must allow a tenant to make an internal transfer under VAWA, give priority to the VAWA transfer when a safe unit is not immediately available, and then if not, take reasonable efforts to assist the tenant who wishes to make an external emergency transfer. So to qualify for an emergency transfer, the survivor must expressly request a transfer from the Public Housing Authority and reasonably believe that there is a threat of imminent harm from further violence if they stay in the unit, or the survived sexual assault that happened on the premises no more than 90 days ago. So this falls under VAWA 12491 as well. Okay, so the survivor can submit any of the following to the PHA with an emergency transfer request as proof that they are a survivor. So a survivor gets to choose which 4 types of documentation to give to a housing provider. So you can use self-certification, a qualified third-party statement, a police report, or a restraining order to show that the PHA that you are a survivor and you need an emergency transfer. However, I will note here that a housing provider can require proof in addition to self-certification if there is conflicting evidence. So this might look like if another tenant or the other party claims that they are the true victim of the domestic violence, then a survivor might need another form of proof, like a restraining order or the police report or a qualified third-party statement.
All right, so previously we briefly discussed protections against discrimination. For example, a landlord cannot automatically deny a tenant's application on the sole basis that a prospective tenant has a criminal record. But now we will discuss additional laws that protect against discrimination. These laws are more general and don't just apply to survivors, but they are important to consider because survivors often face discrimination based on other characteristics. These laws apply to nearly every aspect of the housing market. Almost any time you're engaging in a housing-related activity, these laws will apply. We will go through the Federal Fair Housing Act, the California Fair Employment and Housing Act, and the California UNRUH Civil Rights Act. We will start with the Federal Fair Housing Act. The Federal Fair Housing Act protects against discrimination based on race, color, national origin, religion, sex, familial status, and disability. I'll note that familial status includes whether or not a tenant has children. So if a landlord is advertising for an apartment, but the advertisement says no children, they have violated the Fair Housing Act. The Fair Housing Act applies to most housing, with some limited exceptions for owner-occupied buildings, single-family homes, and housing operated by religious organizations. It applies to the sale and rental of housing, as well as to mortgage lending. A few examples of conduct that would be prohibited under the Fair Housing Act include refusal to rent or sell housing, falsely denying that housing is available for rental or sale, using different qualification criteria such as income standards, or in mortgage lending, refusing to make a mortgage on a discriminatory basis or imposing different loan conditions or terms. I'll note that complaints under the Fair Housing Act may be filed with HUD, the Department of Housing and Urban Development, but the Fair Housing Act also creates a private right of action. An individual may file such an action regardless of whether they proceeded with the complaint process through HUD. Moving on to the California Fair Employment and Housing Act. FEHA, as it's commonly known, includes significantly more protected categories. It prohibits discrimination based on race, color, religion, sex, gender, gender identity, gender expression, sexual orientation, marital status, national origin, ancestry, familial status, source of income, disability, veteran or military status, and genetic information. It also applies to almost any housing-related activity. One specific protection I want to highlight in this context is protection against discrimination based on source of income. A landlord cannot discriminate against a prospective tenant or tenant based on where that tenant lawfully gets their money to pay the rent. What this means is that, for example, a landlord cannot lawfully advertise no Section 8 vouchers, or the landlord cannot refuse to sign paperwork so that a tenant cannot get their Section 8 voucher to pay them. It doesn't matter where a tenant gets their money as long as it's legal. Another specific protection important to highlight in this context is sexual harassment. Under both the Fair Housing Act and FEHA, sexual harassment is a prohibited form of sex discrimination. As those of you who work in employment law may be familiar, there are two main types of sexual harassment. The first would be quid pro quo sexual harassment. And so in this context, that would describe harassment where an unwelcome request or demand is made on the condition of accessing housing or housing benefits. So for example, a landlord demanding sexual favors from a tenant in exchange for allowing that tenant to pay the rent late would fall within this category. The second form of sexual harassment is hostile environment sexual harassment, which describes harassment that is severe enough that it interferes with a person's ability to access and live in their housing. So for example, if every time the tenant sees the landlord makes suggestive comments, this happens all the time, and it makes the tenant want to move, or it puts the tenant in a position where they don't feel like they can ask their landlord to make repairs, then that has interfered with their ability to access and live in housing under both FEHA and the FHA. We will move on to the UNRUH Civil Rights Act. The UNRUH Civil Rights Act does not specifically apply to housing. Instead, it prohibits discrimination in business establishments of every kind. But because most housing-related activity is a business, this also applies, UNRUH also applies to pretty much every activity that the Fair Housing Act and FEHA applies to. UNRUH has fewer specific protected categories than FEHA, but more than the Fair Housing Act. Its protected categories include race, color, religion, sex, medical condition, sexual orientation, genetic information, marital status, national origin, ancestry, citizenship, disability, and primary language. However, I'll note that the UNRUH Act is not limited to the categories that are specifically mentioned in the statute. Other forms of arbitrary discrimination by a business establishment or a landlord are also prohibited, so long as the claim is based on a personal characteristic similar to those identified in the statute. I will note that the UNRUH Act is located at Civil Code Section 51. Civil Code Section 52 discusses damages that are available for violation of the UNRUH Act. It provides for a defendant found liable under the Act can be found liable for a maximum of up to 3 times any actual damages incurred by the tenant, and in an amount not less than $4,000. This minimum damages amount of $4,000 is a recognition that UNRUH violations, discriminatory actions, are per se injurious. The statute also provides for discretionary attorney's fees. Next is how to take action if a landlord is discriminating against a tenant and a survivor. Options include a lawsuit, a letter, or a complaint to an agency. It is very important to act as soon as a survivor suspects there is discrimination, because one often only has a small window of time to pursue a remedy. For example, under FEHA, statute of limitations is, I believe, 1 year. I'll also note, for those of you who practice under FEHA, but in the employment context, it's a little bit different. I believe that the statute of limitations, for example, for employment cases under FEHA was recently expanded to 3 years, but that wouldn't apply. It would still be 1 year for housing discrimination. Also, though, you do not need to get a right to sue letter when you're pursuing a housing claim under FEHA like you do in an employment context. So again, options: file a lawsuit under FEHA, the FHA, or UNRUH, which all allow for private right of actions. Sometimes as attorneys, we can do letter writing on behalf of a tenant, just notifying the landlord that their actions are unlawful and putting them on notice that they could be subject to penalties or liability. A tenant can do that, of course, on their own as well, but it's often more effective when coming from an attorney. And then also government agencies, you can make a complaint under these laws to the government agencies that are the administrator for the law, and those agencies will prosecute the actions in some instances. So a tenant can make a complaint of housing discrimination to the Federal Office of Fair Housing and Equal Opportunity or the California Department of Fair Employment and Housing. That is, I believe, it for us today. I will turn it over to Taylor for some final comments.
Thank you, Rachel. Yes, so I just wanted to note that LAC also supplied supplemental material that we chose specifically for this presentation. So that supplemental material is a lease addendum that was created by the home cohort, and it can be found among a bunch of other resources on the California Partnership to End Violence, to End Domestic Violence website. I picked this resource specifically because it speaks to all, if not many, of the protections that we discussed today. And it's a valuable resource for survivors or other individuals who are interested in adding an addendum to their lease that lists all of the protections, so that it's readily available within the lease agreement itself. Not to say that they have to in order for these protections to apply, but it's a great resource to have. I will also note that we, California Women's Law Center, will be sending out a survey. So we ask that all attendees please fill that out for our sake. And now we'll move on to some questions. So let me look into the chat and the Q&A box. Okay, let me look into the Q&A. So first question is, if we obtain a move-out order for our survivor client, can we then require the landlord to remove the abuser from the fixed term lease? Rachel, do you happen to know?
I would think that it wouldn't matter what the lease term was under the statute. Candidly, I have not specifically faced that situation, but you know, if I would think the court would have the discretion to remove the abuser from the lease regardless of the lease term.
Okay. Next question is, if the survivor and the abuser live in the same home, then the defense against eviction based on DV or for calling the police / emergency assistance would not be available to the survivor? Question. I've also heard the same for ending the lease early due to DV, that if the survivor and the abuser live together, they don't have the right to end the lease early. I believe that this is where the defense against eviction based on DV for calling the police would not be available to the survivor. I believe it would be available to the survivor still. This is where getting a DVTRO would be useful in showing the court. I believe that's the answer to the question. Rachel, do you see that question?
Sorry, yes, I believe that when the abuser is a tenant, look at, I think it's Code of Civil Procedure section 1174.27, which specifically talks about what the court can do when the abuser is a tenant as well at the property. And I'm trying to pull that up so I can answer the question, but I know that there are specific allowances in the law for when the abuser is a tenant as well, and it's not a categorical prohibition against either terminating the lease or getting a lockout order.
Great. So what if the survivor is not on the abuser's Section 8 voucher? Can the survivor still get a Section 8 housing choice voucher? That's a good question. I believe when I'm referencing that the survivor lives with the abuser and the abuser has Section 8, it would be under the understanding that the tenant or the survivor is there with Section 8 knowing or falls under as like a cohabitant for the abuser Section 8 voucher. I'm not sure. I don't have an answer to the question if the survivor is not on this abuser Section 8 voucher, because I'm not sure if they would be a lawful tenant in that case under Section 8. But yeah, I could get back to Joshua, or if anyone else has an answer to that question to put so in the chat, that would be greatly helpful. And then a few of the last questions here. In your opinion, as a general matter, if a housing provider chooses to only list the male income earner as the tenant on the lease agreement, with a female stay-at-home mom to be listed as an unauthorized occupant, is that a discrimination policy due to gender that has desperate impacts on survivors of domestic violence? If the victim / survivor is listed as an authorized occupant instead of a tenant on a lease agreement, does that restrict their ability to take advantage of VAWA or California Civil Code protections?
I can speak to the latter point, that the fact that they're an authorized occupant rather than being named on the lease as a party to the lease would not affect their rights as a tenant in most situations. And then as far as VAWA is concerned, I have less expertise, and I will let Taylor answer that.
Again, I feel like when VAWA is concerned, again, it kind of falls under the same understanding as kind of the last question. Usually, if they are an authorized tenant under the voucher, it's like a Section 8 voucher. Kind of what we discussed earlier is that they would be able to either move out and apply for Section 8 under their own regard if they are eligible, or find alternative housing. And so that's where that would come in, if they do not have Section 8 on their own. But I believe they would, if they are an eligible tenant under Section 8 or another a federally subsidized program, they would still be able to take advantage of VAWA, especially if they're able to show that they are an authorized tenant under that voucher. So for the questions of, can we repeat once more? I believe you'll be getting the PDF of our presentation. So you can review there. I'll read some of the last questions here. Survivor is being evicted because abuser continues to hang around the apartment complex selling drugs and threatening staff. Survivor has obtained an RO and only calls the police when abuser threatens her. Survivor is Section 8 or has Section 8 housing choice voucher. Landlord's attorney continues to doubt survivor DV status and won't give specific details as to what the landlord is using as just caused on UD. Do we have any suggestions?
I'm sorry, I don't have any specific suggestions other than, if the tenant should be calling the police or other authorities, I suppose, if this person is continuing to show up and harass them and get them to enforce the stay away order, and the tenant should have protection against availing themselves of that based on the statutes that we've mentioned.
Yeah, I feel like I had the similar thought as well. The other questions are a bit long, and I know Megan is going to show her play out here, so I think we'll probably end it there. Feel free to email either Rachel or I any other questions you have, and we'll definitely look further into any questions and respond.
Yeah, similarly, if any answer we gave felt like we were giving the question short shrift, I'd be happy to do a little research and give fuller answers if you want to reach out to me by email.
Thank you, everyone.
Yeah, thank you all.
Thank you for joining us for today's webinar. This webinar was hosted by the Legal Aid Association of California, also known as LAC. We are the membership organization for California's civil legal aid nonprofits. Our job is to advocate in the legislature, in the courts, and with the State Bar of California on behalf of the community of nonprofits that serve low-income Californians. In addition to our online and in-person trainings, LAC provides coordination and advocacy for increased funding to support organizations like yours. Thank you.